withdrawing the case.
With liberty, madam.
With
With
liberty.
liberty.
Why you want to withdraw?
Well, some compromise has arrived at.
Some,
Some compromise is likely to be arrived at.
Mr. D.R. Gogoi, learned counsel, declaring to the she submit that there is possibility of amicable settlement in the matter, and therefore they have the instructions to withdraw this petition with liberty to find a prayer. The prayer for withdrawal is not opposed by Mr. J. Sukwan Liner, government advocate of some declaring for this state. In view of the above, these petitions can dispose of on withdrawal with liberty as states.
Oblige.
May I please, Lordship?
Lordship, the petitioner is a lady advocate practicing in the Guwahati High Court, Guwahati High Court, and his husband dead body was found in a suspicious condition at Aizawl. But thereafter, my lord, that petitioner lodged an FIR before dispute PS. But my lord, what happened that without looking into the gravity of the case, though it is a cognizable offence, my lord, covered, but my lord, in a straight way, my lord, it was remanded back to the my lord Aizawl police station. No forwarding report, my lord, no forwarding, my lord, no case was registered, and thereafter, my lord, we inquired to the police station Aizawl, my lord. We came to know that since nothing has been done and no forwarding report was given by the dispute police station, my lord, therefore they in in conversation we came to know they closed the my lord this FIR, my lord. Now, lord, the thing is that my lord, in my view, my lord, once my lord we have closed an FIR, my lord, then it has to be registered first.
Where is the FIR?
My lord, FIR containing page 23, my lord. Now, representation is page 27, my lord, to the commissioner. Please.
This FIR has been lodged at the dispute police station. But the death happened in Aizawl.
No, my lord, death, yes, that happened at Aizawl, but lordship, I just want to point out that it's a matter of property dispute, my lord, where some persons are involved, one brother-in-law law is also involved. Therefore, if suppose they would have recorded my 161 statement, thing will come up, my lord, on surface. But no access was contemplated, no FIR was registered, my lord. Even it has not been treated as zero FIR, my lord, which is the part of suppose revised case 2012, my lord. Straightway, my lord, just remitted back to the my lord Aizawl police.
Where is the certificate of the hospital? Aizawl
Yes, my lord. My lord, that hospital, the postmortem was done, and subsequently we received, my lord. Lordship, only one document we could procure, my lord, because the was not in a mentally fit condition, therefore somewhere.
Postmortem was done.
It's purely a case of my lord, planned murder, my lord, in our view. If in our view, my lord, it's purely a case of planned murder, my lord.
That has to be seen.
My lord.
Subject matter of
My
inquiry.
lord. Lordship permits, I just want to place two cases if Lordship permits. This is my lord, one is a Sushant Rajput's case, my lord.
No, Mr. Chamaria, you forget the case.
My lord.
You tell us what is the material for the court to presume that there is something wrong in this.
My lord. My lord, first thing is that, my lord, while my lord FIR has been lodged, my lord, this is cognizable one, my lord, it has to be registered first. And second stage, my lord,
What is the cognizable offense?
my lord, cognizable 2C clearly says, my lord, which my lord, schedule 1 covers, my lord. There is a case of, my lord, we want to say it's an unnatural death, my lord, in our FIR clearly states. Therefore, my lord, if suppose my statement would be recorded.
We'll do one thing, we'll issue notice. That is because it's a sensitive matter, the petitioner may feel, but you have not made out any case. We'll close it on the next day.
Right.
This kind of cases, the Read court can't do anything.
Right.
You only say that according to you, it is a property dispute.
Yes.
That is not good enough for the court to go deep in.
My lord, my praise that.
The medical report says the death due to cardiac arrest.
Absolutely, my lord.
So what can the court do now?
My lord, thing is that, my lord, suppose if investigation is carried out, my lord, then my lord, something will come up that actually it is a natural death, it's an unnatural death, my lord. But without there is a case, no investigation is carried out by neither by the Dispute police station, nor by the IJOL, my lord. That pain will remain forever to me, my lord.
Who is for the respondent?
My lord, 1, 2, 3 is status.
Are you appearing in this case?
Yes, your lordship.
What
I'll
is
bring instruction, your lordship. From respondent number.
There are procedures under the CRPC. You have not availed those.
My lord,
There are procedures under the CRPC in these circumstances.
my lord.
Police has closed the matter.
My lord, the information that we have received, IJL has now closed the matter because no forwarding report was given by the Dispute police station. Just in a casual manner, they sent this FIR to the IJL police station. It was intimated to us over telephone by the concerned police station's officials. My lord. So therefore,
I will issue notice only at this stage. But prima facie, it appears that incident is tragic.
no, my lord,
They're
that is
not
there.
saying anything. But emotions will not be enough.
Yes, lordship, quite right.
You have not made out any case.
But the thing is that, my lord, suppose that is there, no doubt, my lord, that is natural, that is so
You must know that it's a very poor case presented before the court.
Hello.
We can't pass orders on emotions.
No, absolutely, quite right,
Death
absolutely.
of a person.
Legal,
52
my lord, legal
years is
basis
a
must
very
be there, legal
tragic
basis
case.
must be, I accept, my lord.
And the court has full sympathy for the family. But
My lord,
we'll still give her a chance to appeal.
My lord.
Not Mr. Chamali and counsel. Yes, Chamali and counsel. For the election. Alleging inaction on the part of the police for that dispute as well as ISO take appropriate action on the basis of the
अपनी
FIR
copy दो।
dated 8/10/20
तीन
by
का ले
the
लो।
petitioner reporting
I jump to 101 में।
death of her husband Sanjeev Kumar Rama
I jump to पहले हुआ।
as suspicious circumstances. The instant petition has been filed, seeking the writ of mandamus directing the respondent to register the FIR and carry out proper investigation in the matter. This case before married government advocate Assam, very important
1, 2, and 3.
state of Assam has appeared had sought 4 weeks time to obtain instruction in the matter. In view of the you should notice a motion regarding the instance. Things may spoken has appeared in accepted notice. Therefore, respondent number 1 to respond. No warning notice is required by the same state respondent. Extra copy of the petition funds for this case. Stop petitioner takes the service and notification respondent by the instant. That is matter the mistake again after 6 weeks.
my lord.
अब लाइन में।
Review.
Lordship in item number 2, and Nimka will be appointed, my lord. Nobody's name is shown in the cause list.
Jail appeal.
Yes.
This appeal has been filed from the jail. However, none has appeared for the appeal. We are done with the also is present on behalf of the state. Registry to engage in because from the tenant prepared by this book and list the matter thereafter, writing the name of the amicus within the process.
Item 3.
May I please, your lordship? Lordship, statutory appeal, lordship. In this case, lordship, the appellant convicted under section 302 of IPC, lordship.
So we'll admit these are all.
Lordship.
Or Mr. Ayub Chaudhary.
Lordship, Ayub Chaudhary.
Counsel is planning to the appeal. His appeal is directed against the judgment. Dated 26/9/2022, passed by the learned session judge Kumar Napraja in sessions case number 54 of the 2007, convicting the under section 302 of the IPC and sentencing him to undergo rigorous imprisonment for life and also to pay fine of rupees 5,000 with defaults with motion. We are filling the grounds taken in the memo of appeal and have also considered the submissions advanced by the learned counsel for the parties. Admit the appeal, call for the LCA, issue notice returnable in 6 weeks. Since Mr. J. Das, learned counsel assistant. Yeah. Learned senior counsel, bracket also accepted notice from the state. No formal notice was accepted. Respond number 1. Into however take steps. No service of notice upon respond number 2 by registered.
Lordship, Aya is there, lordship.
I issue notice also. We'll consider.
We'll file our
Lordship.
objection.
Lordship.
So-and-so was applicant so-and-so to the state, assisted the so-and-so to the state. These I have been filed to declare to suspend the jail sentence and also to release the applicant to appellant in jail and declared making this IA shall be considered upon this LCA. Issue notice returnable in 2 weeks. Since so-and-so has accepted notice for this day, you can take steps. For service of notice upon the OP number 2 by registered post within 3 days from today. The opposite parties may file objection in the meantime. The third part will list the matter again after 2 weeks. The opposite parties may file objection in the meantime. If so, advice.
Obliged.
Your paper book is ready, ma'am.
The learned amicus curiae is not present. We are having senior counsel, deputy were assisted by Mr. Swans. Some is that the appeal has already been admitted in the paper book is also ready. As such, the appeal is ready for final register to verify.
Lordship, because informant is the head, village headman, probably notice may not go. Because he is not the victim. Informant is not the victim, my lord. So, my lord.
Appears that the informant in this case, not a member of the victim's family as such, services notice in the informant is not deemed necessary. Registry, therefore, verify and list the matter for hearing individual case.
Papers, paisa,
Yes, Your Honor.
Informant is required to be served.
Lordship, don't have any papers, my lord. I don't have any papers available.
Lordship, LCR has not yet received.
Informant to.
Mr. B. Bhagwati, learned amicus curiae is present on behalf of the appellant, Mr. Ms. B. Bhuya, learned APP Assam, has appeared on behalf of the state. It appears that the records as called for have not yet been received by the section. In view of the above, let this matter be listed again after receipt of record, receipt of LCR, or 6 weeks, whichever is earlier, with appropriate office name on the status of record as well as service of notice upon the respondents in this case.
May it please your lordship. In this case, also Gosling shows the record received, but paper book is not prepared yet. Registry may be directed to prepare the paper book first.
What about service?
Service, it was direct, I am appearing as amicus curiae, lordship, and it was directed to the registry to serve notice on the informant.
No, informant ko na jana.
Who's the
Ready,
informant
nai.
here?
Lordship,
Paper-
papers are nine.
papers, no.
Notice has not been issued to the informant. You don't have papers.
No, lordship.
LCR has been received. Mr. A. Learned amicus curiae is present on behalf of the appellant. We are APP Assam, assisted by Mr. So is present on behalf of the state. The LCR as called for, LCR, as called for by this court, has been received. However, the paper book is not yet ready in this case. Registry to therefore expedite preparation of papers. The office would also verify as to whether the informant is required to be served in this case or not. And if so, this the matter again with appropriate officer.
No, lordship.
Papers, paisa. Papers, paisa.
Your Honor, I took the step as per the order of this honorable court. Notice to the,
Appearing as legal aid counsel.
yes, Your Honor.
You were required to take steps to. How can the legal aid counsel take steps to
To
do?
registry, your lordship.
Actually, I took the step, Your Honor. I took the step,
Yes, yes.
Lordship.
The order says legal aid counsel to take steps through the officer in charge of Bogriwari police station. Can she do that?
Registry can do that, and I may also obtain instruction from the OC concerned, my lord.你补贴什么？
Heard Ms. M. Das, learned legal aid counsel appearing for the appellant. Also heard Ms. B. Bhuya, learned deputy assistant assisted by Swinson, appearing for the respondent number 1. Perused office note dated 21/10/2022. It goes to show that LCM is still awaited. From the order dated 12/9/2022, as well as the office note dated 30/9/2022, it appears that the learned legal aid council has taken steps for service of notice upon respond number 2, a registered post with AD. It has not been acted upon. In view of the observations made in order dated 12/9/2022, requiring notice to be served upon the respond number 3 through the officer in charge of Babribari Police Station from our district Kokrajhar, from Assam. After hearing the submission of learned counsel for both sides, we direct the registry to send the notice. Send notice to the respond number 2 is served to the officer in charge of Babribari Police Station within 10 days from today. Insofar as steps taken by the learned legal aid council concerned, office may issue notice by registered post with AD. Now, insofar as the steps taken by Ms. Das by registered post with AD is concerned, the same may also be sent to the respondent number 2. Let this appeal be listed again after 4 months with appropriate.
If this is a state appeal against the acquittal of 2 numbers of accused, the notices have gone on the last occasion. There's an office note of 27th of October where it is said no report from the OC is received as of date. I can take instruction from the OC Sibsagar. It's a POXO case where both of them were acquitted.
Mrs. John and APP Assam appearing for the applicant. Also payroll office note dated 27/10/2022 was to show that no service report from the OC Sibsagar police station has been received till date. Ms. Jahan submitted that she will permitted 2 weeks time to call for report from directly from the OC Sibsagar. As regards status of service of notice from the respondent numbers meant to in this case prayer allowed. Let this matter be listed again after 3 weeks.
Lordship, I beg to mention item
We
number,
have fixed the matter. Now you,
I have received the paper book
yes. They passed an order.
and in item number 9, your lordship.
9, my objection is there as far as I is concerned.
I will file my counter affidavit and accordingly.
What is this? What is this I hear about?
I is for bail suspension of sentence.
Suspension of charges.
He need not file any counter.
Counter affidavit, there is no scope. You want to argue, you argue, otherwise we'll adjourn it.
Let the matter be fixed the first week of December, if lordship permit.
Dr. B.N. Gogol and counsel for the applicant submit that he has received a copy of the objection filed to this IA on behalf of the state. But 6, posting of this matter again in the first week of December, so as to obtain instruction from his client and argue the case. The prayer is not opposed by Ms. S. Jahan, learned APP Assam preparing for the state. Stop. In view of the above, a registered municipal matter for orders again in the first week of December.
Ten record is it? Records are here, 10 service is not complete. Check the office note.
POSCO Act, my lord, section 6, sentence to life imprisonment. There's a miss case was there.
No AD card or unserved notice I've checked, I've seen.
What is the number of the miscase?
My lord,
Miscase number?
504.
5049.
504 है, missed or something.
504.
So it's a POXO matter, notice has to be served.
Yes, ma'am.
There is a judgment saying that the victim has a right to represent in each stage of the trial, prosecution, everything, even in appeal.
Judgment of which court?
The Supreme Court. I have this judgment, Lordship can just see this. This is Jagjit Singh versus Ashish Mehra. Every time we get new decisions, Lordship will see this. Victim has a right to appear.
What one, eh?
Report, who is there? Manu Patra,
It's in business.
State of Madhya Pradesh.
Jagjit Singh versus State of Madhya Pradesh. All right, so if there is a Supreme Court judgment, we'll have to follow it.
My lord,
We will follow it.
my,
Then we have to await service report.
my lord.
You have
And
filed
in
your
the,
objection.
no, in the meantime, we will file our objection. Last time Mr. D Das appeared, when there was no order for objection, so
I
I'll
heard
file.
Mr. B.M. Chaudhary, learned counsel appearing for the applicant, also heard Ms. S. Jahan, learned APP, some state to praise for another 2 weeks time for filing objection. First, perusal of office note dated 31/10/2022 indicates that the service report for number 2 is still awaited. In view of the above, let this matter be listed again after 3 weeks with appropriate office note. In the meantime, statement file objection. If so advised.
I'm obliged, worship.
Want to wrap up?
What is the code you want?
Please, your lordship. This is I for condemnation, lordship. Lordship, as per notice, notice has been served, issued on 5/11, but report has not been received. So, add for service, lordship.
Is I is for suspension of sentence.
No, lordship.
It is for the condonation,
This
delay.
is the condemnation.
There is a
for
delay.
How many days delay?
114 days, lordship.
This is appeal against acquittal, no?
Not,
No?
conviction 10 years, lordship.
Oh, conviction.
Yes, lordship.
For life.
For life imprisonment,
Santos
lordship.
Hebram. For life. How many days? 100 and?
114 days.
203 days, device, but
114.
Let it be heard on merit. I'm not objecting to it since it's only 100 something days. But the notices have already gone to R2.
Notice has been sent on 5/11.
No,
Yes, lordship.
very
What to
recent.
do? If notice has gone on 5, we have to
Yes,
wait for some time. But Mrs. Chakravarti, learned legal aid counsel appearing for the applicant, also heard Ms. S. Jahan, learned APP Assam, appearing for the state. This note dated 5/11/2022 indicates that notice for service upon respondent number 2 has been sent only on 5/11/2022, but no service report is still available. In view of the above and on the request of learned counsel for the applicant, this matter is directed to be posted again after 3 weeks with appropriate notice. We'll draw presumption and condone the delay, but we have to follow the procedure.
Okay.
Yes.
Much obliged.
Yes,
May I please, lordship? Lordship, this I is for continuation of delay of 72 days, lordship.
Against conviction.
Against conviction.
so you have included the informant.
Yes, they have not, I think. Informant was implicated.
They have.
Informant is Ajit Beg-
Condonation of delay is informant required.
Not required, it's up to your lordship actually, whether it's delay or leave. It's solely up to your lordship. So this is less than 100 days. I pray that the
We condone the delay.
lordship.
The other matters is notice has gone.
Hmm.
These are matters regardless of what the informant says.
Hmm,
Let's
yes.
go by- Heard Miss D. Babuleri, learned counsel by the applicant. Also heard Miss S. Jahan, learned association representing the restaurant number 1. First of all. This IA has been filed under section 5 of the Limitations Act, 1963, with a prayer to condone the delay of 72 days in preferring the connected appeal against judgment and order dated 10/5/2022, whereby the applicant was convicted, judgment in order dated 10/5/2022, passed in connection with is it 10 or 11?
It is 10 logic. Ordered this.
In connection with Golaghat Sessions case number 44/2018, convicting the applicant under section 302 of the IPC and sentencing him to inter alia, ergo rigorous imprisonment for life. First up, we have perused the explanation furnished in the IA. First up, Ms. Jahan submits that she has no instructions to file any objection opposing the prayer made in the IA. First, considering the explanation furnished by the applicant and also taking note of the fact that this is a statutory appeal against judgment of conviction, we deem it appropriate to dispense with service of notice upon the respondent number 2 and condone the delay at this stage itself so as to expedite listing of the connected appeal. Ordered accordingly, delay of 72 days is hereby condoned. Registry to office to register the connected appeal and list the matter for admission. IS stands dispensed.
Part 2 matter, item 9.
Yes, here lordship wanted me to look into whether the 313 is not properly recorded. In fact, one more question that lordship has posed, that the question whether you want to adduce any evidence, defense evidence, whether that will result in some prejudice. There I have got few decisions of the High Court as well as other High Courts, not Supreme Court, that this will not prejudice the accused, because accused has a right under section 232 to adduce evidence. They will be given that right once the trial court decides that he'll not be acquitted. So he has that stage. So 313.
But it has to be, he has to be offered that opportunity.
But 313 not questioning will not be fatal.
That's correct. 313, the accused has to show prejudice. Sometimes prejudice is inherent, it's apparent. Sometimes it is not. But the more fundamental issue is the CRPC lays down the procedure which is to be followed. And according to the procedure, after the prosecution witness is recorded and arguments are heard, the court can either acquit or if the court decides not to acquit, then the court has to offer an opportunity to the accused to adduce evidence.
Yes.
Now, in many cases, we have seen, for whatever reasons, my learned sister will probably be able to throw more light. This exercise is perfunctorily done at the stage of 313.
Yes.
Which itself is wrong. But here is a case where it has not been done in the 313 stage also.
313 stage also. And one more thing, the questions that were put to him, where you have killed your wife, But the deceased apparently is not the wife of the accused. I couldn't make out a relationship between the two, but in the judgment, the trial court writes that the accused is the uncle of the deceased. And questions were put, you have killed your wife and all that. That mistake is there. But incriminating substances being put to him, put to the accused, those are the only incriminating materials. That PW2, I think, yes, PW2 had seen that you had assaulted the lady, and a stone was recovered, was seized, and the doctor's report. These are the only 3 incriminating materials that are there on record. So those 3 questions were put. Prejudices as far as the incriminating materials being put, I don't see any.
No, that probably,
Wife and the question that you
let us see
want to
228,
reduce.
let us see the CRPC.
Lordship. 232. Two 233 is the entering upon the defense, trial before a court of session. So, Lordship will say section 233.
So the expression is, he shall be called upon.
Huh. Yes, he shall be called upon to enter on his defense.
So at least there has to be substantive compliance of this
Hmm.
provision.
Lordship has raised this query long back also. That time we had checked and we found that not giving an opportunity under 233 will also not be fatal. Something I got that time. If he had the opportunity, of course, to adduce evidence, 313 it is done, but here it is not done.
No, no, Ms. Jahan, that matter which you are referring to, if I remember correctly, there the question was put to him in 313.
In all cases, in fact, I've seen it
But
is
here
put.
it has not been
It
done.
is not put. So I'll just check the judgment. Judgment also 233 does not speak of. 232 here, treat he does not speak of. I've checked it. And plus the wife part. Plus you have killed your wife. So the deceased is not his
You have
wife.
killed your wife is an accusation which the court cannot make. It is not for the court to suggest anything. The examination under 313, these things have been clarified in that judgment, I believe. Sweta, these things have been clarified.
A lordship has also passed that, yes. The case name was not Shweta. Shweta is the deceased.
Yes.
Yes, yes. Lordship is in detail wrote everything.
But anyway, these judgments could be prior to that. That's another matter. But the point is, when does the accused get a chance to
Adduce evidence.
enter his defense? He has not declined it. He was neither offered nor declined.
It was not offered anywhere. That flaw is there.
There is also nothing to show that he had even remotely had a chance to decline. So just after 313, the judgment is delivered.
I'll see the case record once, order sheet. If something is.
Jahan, we would like to give you one more day to look up some judgments on this. What about, do you have any judgment? 233? Nothing.
Nothing.
You have done nothing last 2 days.
No, no.
Job is over.
I have already submitted last occasion to judgment before your lordship. In the last occasion, I have submitted regarding that.
What have you submitted on 233?
230, no, I have submitted on 330 only.
233, I've got that, our High Court judgment where it is said, it may not be put in 313, but 232 if is apprised of, then there is no prejudice. But then I'll find out some Supreme Court judgment on this. They have referred to some Supreme Court judgment. The judgment was by Justice Amitabh Roy and was with another honorable judge. But they have not gone detail into 233 part.
Then we'll settle the law here.
But Supreme Court, I might get something. Tomorrow, Lordship will take it up.
So tomorrow we take it up on Tuesday, coming Tuesday.
Yes.
And let us settle the law here. My
Order
view
sheet,
is-
there might be something.
You have a look at the order sheet also.
After arguments.
At any stage, was the accused offered an opportunity to adduce evidence?
This is what, yes.
Generally, what happens in the lower courts
Mhm.
or lower judiciary, the 330 is the only stage where the accused was offered the opportunity whether he is going to adduce anything or what is his defense. But in this case, most probably, I think that there was no such thing.
Even that is not correct. 313 stage is not correct.
313 stage is also not correct.
That part also needs clarification because these are all stages before the court decides whether
Yes.
the accused should be acquitted or not.
Mm.
Prejudice is inherent in these things.
Yes. Here, accused B2 Baba produced from jail, fix so and so for argument, accused is remand to jail hazard. Oh yes, he has declined to adduce evidence. Lordship will see here. Accused B2 Praja, the order was on 7/9/2018.
Can you flag it?
Yes. 7/9/2018, B2 Praja is produced. He is examined under 313. Accused is directed to enter defense. The case is posted on 29 for defense evidence. The accused be remanded to custody till then. Then on 29, the accused is produced from custody. He declined to adduce evidence. So the case is posted for argument. Accused is remanded. This, of course, this opportunity is given. Chief will see this once. You know. After 313, enter evidence and then. There are two short orders, Lordship may say. Mm. 233.
So the whole case here revolves on PW2. What do you have to say on PW2?
PW2, she was outside her courtyard, she said, outside her home in the courtyard. And these were all relatives, uncle, aunt, and everybody. So they were staying nearby. And then she saw the accused. There was a quarrel also before that. That quarrel part had not come in the evidence, but there was a quarrel. And then in 161 statements also that quarrel has come. After that, he hurled a brick on the head of the deceased. Then he dragged to the house of the accused. There I thought maybe he is the husband he dragged because from the place of occurrence, the body was recovered. So they were all staying nearby. And then nothing happened. She did not shout. She did not tell it to anyone. She said, her husband came, PW1, and she apprised her husband of that. Then in the morning, people went and found the lady injured. She was taken to the hospital and she died at 9 p.m. at night. So PW2 statement, she being the eyewitness, coupled with the statement of PW1, as well as the recovery of the stone at the site of the deceased. And PW5 had said that the stone was blood-stained initially. Later on, he did not see the stain.
Why did this incident take place? Anything on record on that? Was there a quarrel? You said somebody.
Yes, there was a quarrel. Of course, it has not come. Lordship will see this 313 statement, 313 statement. Oh, no, not 313. Died at night, informed the government. Three one three of PW2, 313 was 161, no? PW2. PW2 নামটো কি আছে? Dipali Nayak, no, Dipali Proja, no? Dipali Proja.
So she had not, PW2 has not told the police under 161?
No, she had told the police. Same things, I've read that day. Same thing she said. And she also spoke about, somewhere I've seen that, I'll just read out the 161. Yes, Proja. This is Dipali Proja. Very short statement. More namu ঠিকনা ওপৰত দিয়া মতে সত্য মোৰ জুৱা নিশা ৰাতি প্ৰায় 11-12 মান বজাত
6 AM. There is a lots of contradiction in income.
No, it was night time only 11-12. It was night time only 8 PM. No, 6 PM. Acha, she said প্ৰায় 11-12 মান বজাত সবিতা প্ৰসাদ হেৰি মৃত্যু খাই মূৰত এটা পাথৰ মাৰিছে মান বজাত
সবিতা প্ৰজাক বিটু প্ৰজাই মূৰত এটা পাথৰ মাৰি হত্যা কৰে ঘটনা কৰি মানুহটো পলায়ন কৰিছে
that hitting part is there.
You are reading from the 161.
161.
You know, just.
I'll flag mark. According to judgment or assembly?
Even motivation is why. अपनी 31
No, hatred over affair.
Yes, do you have anything in reply? Because BW two, most probably she is the main witness. She's eyewitness. And as per the prosecution, she saw while hitting this, brick and dragging the body. She is the main eyewitness. Apart from others are the hearsay or she reported. And do you have anything?
I want to say something, Lordship. In her cross-examination,
In her cross-examination?
in her cross-examination,
Yes.
W2, she did not make any human crime and
Yes.
informed the matter to other locality. It was darkness at 6. She herself stated that it was darkness. How she recognized that person? He stated brick, but stone was recovered. As per the statement of the IO.
But is there any statement wherefrom we can infer that she could not identify the person who was hitting the deceased with a stone and not? Is there any statement from where we can see that she made identification regarding the part of
No,
identification?
her conduct was quite unnatural. Normally, what happened? She should inform the other people, neighboring people. Here, all the prosecution witnesses are related. She is also related witness.
Mr. Das,
Lordship.
it appears to us they are all villagers who live in a close proximity, correct?
Lordship.
It was dark at that time. It appears that the PW2 did not comprehend that this incident could be of fatal nature. It appears that she thought it was a quarrel between two persons who are known to each other. And there some incidents have happened, some assault has taken place. But she could not comprehend that it would be of such a nature that the person would die. So therefore, that possibility cannot be ruled out that she did not speak about the matter to others because believing that it is yet another instance of a quarrel between two persons.
Lordship.
So therefore, ordinarily someone who sees a quarrel is likely to report, but it may also happen that if it is between two known persons, if it is amongst the close knit villagers, it may happen that someone might choose to ignore it for the time being.
in the CD, nothing has been mentioned as to where the dead body was lying. Similarly, nothing has been mentioned as to where that occurrence took place. In exhibit 2, I had not mentioned the exact place of Hatigor village where I found the material exhibit 1. I did not take signature of the seizure witnesses. The material exhibit 1 was not sent by me to FSL. So this is the statement of the IOL.
So what does it mean? The IOs never carry out perfect investigation.
Now, that is-
In Assam, it is even more terrible. But does it mean we have to give acquittal in every case on that?
No, no,
The IOs don't know how to do their job. That's an established fact now.
yes.
They are not interested. But if we find there is no evidence, then we'll have to acquit.
Another aspect also, FIR has been filed after 11 days from the date of incident. No explanation has been given.
No, explanation is there in the FIR itself
No,
that
page 4.
I inquired about the matter. Initially, they thought that the woman had hit something and died. But when he inquired, Dipali Naik informed me, as such, lodging of the FIR got delayed. Some explanation is there.
No, but 11 days.
11
11
days,
days.
but
Incident occurred on 26 February 2016 and FIR filed on 10 March 2016. There is no proper explanation.
PW1 says he has informed the police the next day.
informed the yes, PW1 said the GD entry was made in the case diary. I also know. Next day, I verbally informed the matter in the police station. And the police says, on 26/2, on 10/3, I was working as so-and-so. The occurrence took place on 26/2. I was on training. The first police.
Lordship may kindly come to page 21. Cross portion. The place of occurrence is situated at a distance of about 6-7 kilometers from Berikuri PS, but the Ejar was lost after about 15 days of the occurrence. In the Ejar, there is no endorsement to the effect as to who took the LTI of Anshu Praja. Anshu Praja is the informant, son of the deceased. He was also not been examined in this case.
This GD entry was made on the same day itself, 26/2, and the investigation started. This FIR is actually 162.
162.
Everything was done after this GD entry.
Where is
But
it?
that
GD
is
entry
page 18,
that has been exhibited.
not been exhibited, not
The
exhibited.
LTI is also not been proved, Lordship.
And,
Photocopy of the
So,
CD.
Mr. Das, you sit down, make note, and then once your turn comes, you reply. This running commentary is not permissible in this court.
GD entry is not exhibited, but the police said the GD entry, I was working as attached officer. On that day, I received an information that a woman was murdered. I was absent. On that day, OC was absent, and I was directed to conduct the preliminary. GD entry number 420 dated 26 was already made. It was made by Havildar. I recorded statement, dead body was lying at the place. So I sent the dead body for inquest and all. So everything was done after GD entry.
Yes, what do you have to say?
GD entry, of course, is not exhibited, but the fact remains that everything was done after the GD entry. This FIR loses value as FIR. 26/2 GD entry was made. In certain one of the case I've seen GD entry was not exhibited, but it was taken into account, depending on the facts of the case, of course. Here, the police says about the GD entry, but he did not exhibit. It is there in the CD also. I've seen the entry 420. And they give a reason that the OC was not there. He returned on 10/3 from training. Thereafter, he received that FIR and it was entered into.
So in that GD entry, the name of the accused is there.
GD entry, yes. GD entry, name of accused not there. Simply woman was murdered. After they come to the place of occurrence, then they were informed.
The person was informed. DW
Uh, Now, who was the person? Even I did not find it there, but it was they had come and took the statements of the witnesses. Witnesses' statements were recorded on 27/2. Then they had come to know. Arrest was made much later. Arrest was made on 11th. No, arrest was made on 11th. Arrest was made on arrest was, I've seen arrest was made on after the day, it was 11th of March, arrest was made. Flaws are there, of course, those flaws are there. But defect in investigation, if we have good evidence from the witnesses, there is an eyewitness, even motive is, if in the absence of motive, it will not matter. So there is an eyewitness, she has seen, as your lordship had said, she did not think it so grave that she needs to shout. She did not shout. She was the injured was dragged by the accused. When her husband came at 8 p.m., she said, morning, she was alive, morning at 9 a.m., she died. It can be not an
any timing of recording the GD entry.
timing is there. Timing is there. The case diary is there on the left hand. Picking up a brick and hitting at someone's, of course, head, vital part. But there may not be that intention to kill. And the woman did not die instantaneously. She died next morning. So there can be some scope for conversion to 304.
Part 2.
304 part 1 or 2 without intention part 2.
But where is the evidence to show that there was a quarrel?
That is what quarrel part. I think I've seen in other people's evidence somewhere quarrel, but not before the trial court.
DTP secretary.
Quarrel is not possible. Don't decide. Huh? Not to liquid hollow, how many videos here?
ৰাতিপুৱা পুলিচক খবৰটো পায় that time the lady had died. তাতে কোনো ট্ৰিটমেণ্ট নাপায় কাৰ্ডিয়াক পেচেণ্ট কিবা এটা হৈ আছিলে মাৰিলে For conversion of an.
FIR খনতো নাই, চালো অৱশ্য। FIR খনতো নাই। The exact copy, the extract copy of the GD entry, not in the record.
Premeditation to 9. Conversion to burning. Do 161. Evidence to believe what. Second happened because. Trial was made by a brick. Obviously, after a brick. So it was a sudden development. Without any premeditation. He was busy. The people I was there. There is always. Investigation and prosecution. As well as even when defending. Okay, defense. Companies. There are evidence and report both in a. This is the evidence of the short. And justice. The aspects of the great manner. We feel that meditation. All right, Mr. Das, we'll reserve the judgment. We'll see if this can be converted into 304 part 2. Well, one thing is very clear. There was no premeditation.
There was no premeditation. Had there been, he would have taken some other weapon. There was.
How many years he's been in jail?
From the date of judgment.
Before that? 18. So this was November 18, 2021.
During trial, he was on bail.
During trial, I don't think so. He was, I'll just see the GR records. This is put up, jail hazard. She was inside pain, YouTube from jail. In the records of judicial magistrate, he was, she was in jail. He was in jail. And in the trial court record is with your lordship. I think he was in jail throughout.
Okay, we'll examine it.
From, yes, from 2016, he is inside March, 11th of March. 2016.
That means almost 6 years.
More than 6 years.
So that is it. We'll see. We're not saying that the PW2 is not dependable. That conclusion is difficult. She has seen it. Why would she falsely implicate? There is no suggestion also. The only thing that we need to consider here is whether it can be a case of conversion. A poor investigation, sloppy prosecution, and very, very incompetent defense lawyer. All three come together in criminal trials. That is what makes our job difficult. Otherwise, we can dispose of 10 appeals every day. Everybody fails to do their job. And then we are to find out who is more guilty. That is all about hearing criminal appeals. Who is the worst amongst the three? All of them are poor, not here at the trial court level. That's the whole job. That's the whole purpose of criminal appeal. What else is there?
There will be a GD entry which will not be exhibited. Maybe the prosecutor does not even know that it has to be exhibited. And then it turns out to be a game of chess. You make one move, they make another move. We are not here to do all these things. But Mr. JP Das, learned amicus curiae appearing.
Jay Das.
Huh?
Jay Das.
Jay Das, amicus curiae appearing for the appellant, also heard Miss S. Jahan learned APP Assam appearing for the state. Arguments concluded, judgment reserved. Yes, next matter. Yes.
Part two, hearing item one.
Live stream. Yes.
Well, this is conviction number 302, my lord. He has been, my lord, sentenced to, my lord, life imprisonment, rigorous life imprisonment, my lord, and my lord, fine of 5,000 in default, my lord, another 1 year, my lord. But the allegation is, my lord, that he has killed, he had killed, my lord, his 2.5-year-old daughter. And, my lord, the informant is the wife, his wife, my lord, the mother of the child. My lord, there are 14 witnesses, my lord, who examined, my lord, including the, my lord, the investigating officer and, my lord, doctors, my lord. There are no eyewitnesses. Only, my lord, eyewitness, my lord, is the wife, my lord, who is the informant, my lord. And, my lord, there are 2 stab injuries, my lord, as per the, my lord, doctor's report on the test, my lord. And, my lord, all other, my lord, eyewitnesses, my lord, they're all hearsay, my lord. They all heard the incident. And in fact, my lord, there are contradictory, my lord, statements. Some of the villagers say, my lord, that the wife killed the, my lord, child, my lord. And all of them were declared hostile, basically, my lord, because they, my lord, stated that, my lord, they heard that there was some confusion with regard to who killed the child, my lord. The judgment, your lordship will find at page 47. My lord.
Yes.
Lord, the discussions, Lord, on the, my lord, the PWs, my lord, the statements to PW we discussed from, my lord,
So why don't we start from the Ejahar?
My lord. Ejahar is page 4, my lord.
Yes.
Humble submission is that at around 7:45 AM today, on 24/7/2016, the aforesaid accused, that is my husband, took our daughter Suhana Akhtara, 2.5 years, to the nearby shop, luring her that he would buy her biscuits, and killed her on the road by stabbing her on her chest with a sharp weapon. The accused then pretended to commit the suicide by injuring himself for his self-defense, were therefore free to investigate the incident and take necessary action. So that is the FIR, my lord. My lord. My lord, the charges, my lord, are at page 6, my lord. That on 24th so and so, at about 7:45 AM in village so and so, you committed murder of intent by intentionally causing death of Suhana Akhtara, your daughter aged up 2.5 years, and that you have hereby committed an offense punishable under section 302 within the cognizes the court of sessions, and I hereby direct you to be tried by this court on the said charge. Now, my lord, the PW1 is a doctor, my lord. Page 8, my lord. My lord, injuries, my lord. Lordship will find at the bottom of that page, my lord. A spindle-shaped stab wound, size of 2.5 cm into 1 cm, is present over the front of the left side of the chest, at the level of the nipple, 4 centimeters away from the midline. The margins of the wound are clean and inverted. The direction of the wound is from the left to right side, below upward. The skin underlying the intercostal muscles, 3rd, 4th, and 5th rib, left side, pericardium and heart are clean cut. Spindle-shaped incised wound of 2.2 centimeter, 1 centimeter. The muscle dip is present over the left, over front of the left side of the chest, 2 cm over the nipple, and 5 cm from the midline. And my lord, opinion, my lord, is that due to this hemorrhage and shock as a result of sustained, as described, all injuries are antemortem, caused by pointed sharp cutting weapon, which is homicidal in nature. Then, my lord, PW2 is the informant, my lord, who, my lord, stated, my lord, I'm the informant in this case. Accused Ayub Ali, Ayub Hussain, who is in dock, is my husband. Deceased Suhana Akhtara was about 2.5 years, was 2.5 years old at the time of occurrence is my daughter. That the Suhana Akhtara was my only child who was born out of our wedlock. At the time of occurrence, I was with my husband in my matrimonial house at so-and-so. And after occurrence, I have been staying at Miramaragaon, PS Howley under Barpeta district. About 4 days back from 24/7/2016, accused as well as my husband has been quarreling with me on demand of money to be brought from my parental house. On the day of occurrence, that is 24/7/2016 in the morning, or about 7:30 AM, while I was sitting inside my house along with my child in my lap, then the accused forcefully taken away my child, Suhana Akhtar, from my lap and went out from my house and telling me that he will purchase biscuit for the child. But I had and suspect upon the accused, and as such I followed him. After leaving the courtyard, and while he reached on the road, then he immediately accused, armed with a dagger, stabbed the child in three times in the chest and stomach in front of me, and fell the child beside the road. I raised halla and pick up the injured my daughter child and ran towards the hospital, but suddenly fell down along with the injured child and found the child is dead. They were oozing blood from the injured places of the child. I fell senseless on the road. Someone brought me the house along with the dead child. There was a huge gathering in my house, and after some time, police came to my house and brought the dead body of the child to hospital. On that very day, I lodged the FIR with the police. On that very day, the body of Suhana Akhtar was handed over to us. Just after the occurrence, the accused fled away. In the FIR, I put the thumb impression. The police recorded my statement. On the very night, I left the house of the accused and started to stay with my parental house. I've been staying in my matrimonial house along with my husband, child, mother-in-law, father-in-law, brother-in-law, and nephews. At the time of occurrence, my in-laws were in the house. Well, none of the in-laws were examined, man. At the time of occurrence, my father-in-law and brother-in-law, Isab Ali, were sitting in the courtyard. The neighbors neighbors are residing far away from a matrimonial house. There is also an Angarbadi center and one mosque. The Angarbadi center is running in the rented house of Salam. On the day of occurrence, the day was Sunday. The place of occurrence is just near my house. The place of occurrence is the backside of our house. There is a village road in front of the Angarbadi center. The FIR was lodged at about 9 PM on the day of occurrence. It's not a fact that I did not state before the police that the accused had been torturing me from 4 days back from the date of occurrence. It is not a fact that at the time of occurrence, I was not sitting in my house along with the child in my lap. It is not a fact that I did not follow the accused while he took the child away, child from me. It is not a fact that the accused did not step armed with dagger and kill my child. Now, deposition of PW3, my lord, who is a resident of her paternal, my lord, village, my lord. I know the informant, and at present she is staying in her paternal house, which is nearer to my house. The informant, so-and-so, was married to the accused so-and-so. They had a female child. On the next day of occurrence, when I went to Bhabanipur Panchayat office, and I noticed a gathering at Bhabanipur OP, and I went there to know about the gathering, and I saw that the accused Ayub Ali, alias Ayub Hussain, who was arrested by the accused. I had noticed that the police was interrogating the accused in front of us, how we killed the female child. And then the accused told the police before that us that he had been quarreling with his wife, and thereafter he snatched away the child from the lap of the informant, and thereafter he stabbed the child armed with chaku. As a result, the child was dead. The police recorded my statement. Thereafter, I left the Bhabanipur police outpost. In the cross, my Gaon Panchayat falls in the Howli town. I went to the Bhabanipur Gaon Panchayat on so-and-so. The Bhabanipur Gaon Panchayat falls in the opposite, as well as the northern side of the Bhabanipur police outpost. I have no idea as to how many rooms at Bhabanipur police outpost. At the time of interrogating by the police, I was inside the outpost. There are about 20-15 persons present at that time. In front of the room of the IC of the outpost interrogated the accused. I have no idea about the size of the room of the outpost, but it may be 10 to 12 feet size. I left the outpost about 12:30 p.m. 1 p.m. It's not a fact that I did not stay before the IO. I went to the Bhabanipur police Panchayat, and thereafter I went to the Bhabanipur police outpost. It is not a fact that the accused was not interrogated by the IO in front of me. It is not a fact that the IO did not record my statement. Now, my lord, PW4 is a resident of a village, Moinamara, my lord. About 1 year back, one day, I went to Bhabanipur police outpost. On that day, in the day hour, I had seen a group of 20-30 persons at the Bhabanipur police outpost. And I also seen the accused with standing in the dock in the Bhabanipur police outpost on that day. And I also seen the police was interrogating the accused. And I heard the accused confess before the police that he committed his daughter. I had awaited for some time in the Bhabanipur outpost, and thereafter I left the Bhabanipur police outpost. The police had recorded my statement. My house is about 5 kilometers away from the Bhabanipur police outpost. By profession, I'm a cultivator. I used to visit the Bhabanipur police outpost at intervals. Jihadul Ali, Hussain, Azaruddin, Nasirul, Moinul Haq were among the group. I do not remember the questions put by the police to the accused and the answers given by the accused. On that very day, the police recorded my statement. It is not a fact that Ayub did not confess before the police that he committed the murder of his daughter. It's not a fact that Ayub is innocent. It's not a fact that I falsely deposed against the accused. PW4 5 is one Joinal Abidin. Well, he said, I know the accused Ayub Ali who is standing in the dock. He is residing at Purbhara Gaon. On the day of occurrence, when I was in my shop, and then I had heard that a minor was killed by someone who was the daughter of the accused. Then I went to the house of the accused, but did not see the minor deceased. I do not know who killed the minor. The witnesses declared hostile. In the cross, he states, it is not a fact that I had stated that the police on today that I had heard the accused Ayub Ali killed his minor daughter about 2.5 years old. And in that regard, there is a halla in the entire area of village. And then I went to the house of the accused and came to know that there was a quarrel between the accused with his wife, and the accused took away from the lap of his wife and took her away from the house. And thereafter he killed his daughter, armed with a dagger, by stabbing on the minor. It is not a fact that on 27/6/2016, on the day of occurrence, police recorded my statement. My house is about 2.5 kilometers away from the house of the accused. It is not a fact that I'm giving false evidence by concealing the truth of facts, the case with intent to save the accused. In the cross-examination defense, my lord, I do not know the facts of the occurrence. I had not deposed anything on the alleged occurrence to the police. I had not stated before the police that accused Ayub Ali stabbed and killed his daughter armed with a dagger. Then, my lord, PW6 is one Azaruddin. I know the accused Ayub Ali was standing in the dock. At about 1 year back, I had seen the accused at Bhavanipur police outpost. On that day, I went to the Bhavanipur police outpost for my personal work. I had also seen a group of people, about 30, 35 were present in the Bhavanipur OP. I had seen the police interrogating the accused at the outpost. I had heard that the accused confessed before the police that the accused killed his minor daughter. The police has recorded my statement. In the process, says, I went to Bhavanipur outpost along with my friend so-and-so. On being seen, the group of people at the outpost, I do not remember whether I had stated before the IO that I went to the Panchayat office with my friend Badsha, and having seen the crowd at the Bhavanipur outpost to know what was going on, I could not remember the entire confession made by the accused. It is not a fact that the accused did not confess before the police or before the IO. It is not a fact that I have falsely deposed. PW7. Moinal Ali. I know the informant, Asma Khatun. I knew the deceased Sohara Akhtar, the daughter of the informant. Accused Ayub Ali is the husband of the informant and the father of the deceased Suhana. About 1 year ago, I heard that accused Ayub Ali had killed his daughter Suhana Akhtara. Police apprehended the accused. Then I went to the Bhavanipur police outpost to see the accused. On reaching the outpost, I saw the accused. Police was interrogating the accused at that time. The accused told the police in front of me that he had committed wrong and the police may do whatever they like. In the cross, he says, my house is less than half a kilometer away from the house of the accused. I was in my tea stall on the day of the incident. I heard about the incident from a family member of the accused. I do not remember the name. I do not remember the time of giving my statement for the police, whether I had told the police or not. The accused told the police that he had done wrong and the police may do whatever they like. It is not the fact that the accused did not kill his daughter and did not confess anything to the police. It is not a fact that the accused wife, the informant killed Suhana Akhtara when the accused tried to stop her. The informant assaulted him and also caused injury to him. PW8
Yes.
is one.
We'll come back.
Page 20. I'm the Gaubura, the village headman of Kotagaon, and in charge head of Mazgaon and Purabharal Gaon. I know the accused present here very well. He is a resident of Purabharal Gaon. I know the family of the accused. 1 year ago, Mizarul Haq of Purabharal Gaon informed me over phone that the accused had killed his daughter and had caused injury to himself. Hearing the news, I came to the residence of the accused. I saw the police and the neighbors there. I saw the dead body of his daughter. I saw injuries on her chest. Police took care of the dead body. Before I reached there, the accused was taken to the hospital. Police conducted the inquest of the dead body. I put my signature as witness. In the inquest, Exhibit 2 is the inquest report and Exhibit 2.1 is my signature. I do not remember if the police recorded my statement or not. Cross-examination. I was in my village Pota at the time of incident. It's not a fact that I did not tell the police that Mizarul had informed me about the incident over phone while I was at my house. I did not state with the police whatever I have stated in the court today. I did not witness how the daughter of the accused died. PW 9 is one Kobat Ali. I know the accused who is standing in the dock. I also know the informant, Asma Khatun. The alleged accused hails from my same village. I also know a deceased Suhana Akhtar, the daughter of the accused and the informant. About 1 year back, one day, while I was in my house, I heard that Suhana Akhtara died. Then I rushed to the house of the accused and informant and saw the dead body of Suhana Akhtara. I had also seen the injury marks on the dead body of Suhana Akhtara. I do not know as to why the accused and the informant made quarrel. The police reached in the house of the accused and also there was a public gathering. The dead body was inquested, whereupon I put my signature as witness. Exhibit 2 is the inquest report. Exhibit 2.2 is my signature. The police did not record my statement. At this stage, the witnesses declared hostile. In the cross, it is not a fact that the police had recorded my statement. It is not a fact that I had stated before police that the accused Ayub Ali had suspected the informant and knowingly stabbed his daughter, namely Suhana Akhtara, as a result of she died. It is not a fact that to save the accused from this charge, I am giving false evidence since the accused hails from my same village. On cross-examination for the defense, he says, I do not know how Suhana Akhtara died. I had not made any statement for the police. accused Ayub Ali had also sustained injury for which he was brought to hospital for treatment by his brothers. I have not heard that the informant had illicit relationship with another person for which frequent quarrels took place between the informant and the accused. I have not heard that due to illicit relation, the informant had killed her daughter and also attacked the accused as a result of his sustained injury. PW 10 is one Sahibul Islam. I know the accused Ayub Ali who is standing in the dock. I also know the informant Musammat Asma Khatun, the alleged accused hails from my same village. I also know the deceased Suhana Akhtara, the deceased of the daughter of accused and informant. About 1.5 years back, one day, while I was in my shop in the morning hour, and then I heard some people shouting that someone died. Then I followed the people and went to the house of the accused and heard that the Suhana Akhtara, the daughter of the informant and the accused, was killed. I also heard from the gathering of the people wherefrom someone had said that Suhana Akhtara was killed by the accused Ayub Ali, and someone say Suhana Akhtara was killed by her mother as well as the informant. The police came to the house of the accused and brought the dead body to the police station. And also the police asked me to accompany the dead body, and accordingly I went to the Bhavanipur police outpost where the police had taken my signature. The police also brought the dead body up for post-mortem examination. In Exhibit 2 is my 2-3 is my signature. The police had recorded my statement at the police outpost. At this stage, the witness is declared as hostile. In the cross, it says, it's not a fact that I said with the police that I had heard from the police that accused Ayub Ali had stabbed his daughter by a dagger, and as a result of she died. It is not a fact that I'm giving false evidence that I remember and that I heard that the informant killed her daughter Suhana Akhtara. It is not a fact that police has conducted inquest on the dead body of the house in the house of the accused, and I had put my signature as witness in Exhibit 2 thereof. It is not a fact that I'm giving a false statement to save the accused since he hails from my village. Then on examination crossed by defense, I have not seen the occurrence. I heard from the villagers that the informant Asma Khatun had killed her daughter Suhana Akhtara. I also heard that informant Asma Khatun had assaulted the accused as a result he sustained injuries for which he was brought to hospital for treatment. The contention of the Exhibit 2 was not read over to me while my signature was obtained. I had not seen any conduct of inquest upon the dead body. The police did not record my statement. PW 11 is one Nazrul Islam. I know the accused Ayub Ali was standing in the dock. I also know the informant. The accused hails from the same village as is my neighbor. I also know the accused Suhana Akhtara, the daughter of the accused informant. About 1 year back at about 7 a.m. while I was in my house, I heard a halla in the house of the accused and then came out from the house and rushed to the house of the accused and saw Suhana Akhtara was in the lap of the informant, and near them the accused was lying on the floor. I had also noticed blood stain in the clothes of Suhana Akhtara as well as of the informant. I also came to know that Suhana Akhtara died. The villagers were discussed the matter, and someone stated that Suhana Akhtara was killed by father, and someone stated that Suhana Akhtara killed by her mother. Suhana Akhtara was about 2 years old. The police did not record my statement. At this stage, the witness is declared hostile. In the cross by prosecution, it's not a fact that the police had recorded my statement the very day of the occurrence. It is not a fact that I stated before the police that on today at about 7:45 a.m., the accused Ayub Ali stabbed his daughter, Suhana Akhtara, by a dagger and a hue and cry, and took place in relating to the occurrence. And then I lodged along with the villagers, came to the house of the accused, and I came to know that the accused killed his daughter by causing injury and also inflicted himself. As a result of he also sustained injuries. It is not a fact that I stated with the police that the accused killed her daughter due to the family disturbance quarrel with his wife. The quarrel took place with his wife. It is not a fact that I'm giving false evidence that the villagers were discussed the matter, and someone stated that Suhana Akhtara was killed by her father, and someone stated that Suhana Akhtara was killed by her mother. It's not a fact that to save the accused, I am not adducing the truth of the occurrence by considering the real fact of the case. Cross-examination by defense. I do not know how Suhana Akhtara died. In the house of the accused, I heard from the villager that Suhana Akhtara was killed by her mother as well as the informant. I had not stated anything in relating to the case to the police. I had not stated about the police that the accused had killed daughter Suhana Akhtara due to family quarrel with his wife I had not stated before the police that I had seen the deceased Suhana Akhtara in the lap of the informant with injury and also blood stain in her clothes as well as the clothes of the informant. I have not personal knowledge of the alleged occurrence. Then PWT is 112, so rather is one Jiaur Rahman. I know the accused Ayub Ali who is standing in the dock. His house is about 400 meters from my house. He's a married man, but I do not know the name of his wife. There is a female child about 2.5 years. The occurrence took place 1 year back. On the day of occurrence, while I was in my house, I heard halla in our village. And then on being asked the villager, I came to know that there was a murder in the house of accused Ayub Ali, and it was morning. Then I immediately rushed to the house of Ayub Ali, and I had seen the accused Ayub Ali was lying in the front of his house with blood stain in his clothes. I came to know that the wife of the accused brought the child to hospital. And while he returned from hospital along with the child, and then I saw the child died. And I then I came to know that someone stabbed the child with dagger. I had seen the stab injury in the chest of the child. At the time of occurrence, Ayub Ali was staying in the house along with his wife and the child. We sent accused Ayub Ali to FAAMCH Barpeta. I informed to the Gaambura a murder took place in the house of the accused, and I requested him to come there. In the meantime, the police came to the house of the accused and brought the dead body to the police station. From the date of occurrence, the wife of the accused has been staying separate from the accused. The police has not recorded my statement. While I was present in the house of the accused, when someone told that the child was killed by the accused, and someone told that the child was killed by her mother. The witness is declared hostile. Cross-examination with the prosecution. It is not a fact that the police recorded my statement. It is not a fact that I had stated with the police that on today in the morning there was a quarrel, that the quarrel took place between Ayub Ali and his wife, and Ayub murdered his 2.5-year female child and also inflicted himself. It is not a fact that I stated before the police that on being heard the death of his child, accused himself inflicted injury by the dagger. It is not a fact that I stated before the police that on being asked as to why he did such an act, and then he replied that he is not intending to maintain his conjugal life and confessed that he had murdered the child. It is not a fact that I'm giving false evidence by concealing the truth. It is not a fact that I have not heard this, that someone told the child was killed by accused and someone told the child was killed by a mother. I had not seen the occurrence. I had not seen anything, stated anything to the police in connection with the case. I had not stated before the police that on the day of occurrence, there was a quarrel took place and his wife, and then he made oral confession before us that he claimed his child because he did not want to maintain a conjugal life with his wife. When I came to the place of occurrence, some people told me that the wife of the accused killed her daughter. PW 13. I know the accused Ayub Ali, he is my neighbor. Accused Ayub Ali is a married man and has a female child. At the time of occurrence, the child was about 1.5 years old. On the day of occurrence in the morning, while morning hour, while I was perifill along with the labor, then I heard halla in our village nearer to our house, and then I immediately came to my house. I noticed a gathering on the road, and I also saw the wife of the accused among the people of a child in her, and her child was in her lap. Though I came there, but in the meantime, the wife of the accused boarded in a motorcycle along with her child in the lap and ran away. On being asked, some of the people told me that the wife of the accused killed her daughter, and some of the people told the accused that accused killed his daughter. After some time, I saw accused Ayub Ali was also boarded in a tempo and heard that he was brought to hospital. I also heard that the accused himself inflicted himself in his chest by his dagger. After some time, the wife of the accused returned along with the child in the motorcycle, and I came to know that the child was died. I came to know their oozing blood of the dead body of the child, and as such, I did not see the child. In the meantime, the police came to the house of the accused and brought the dead body to the FAMCH, Borpeta. The police did not record my statement, though I was present. Police rushed to the house of the accused. The witness is declared hostile. In the cross-examination of the prosecution, it is not a fact that the police recorded my statement. It is not a fact that I stayed with the police on today. In the morning at about 7:45 a.m., I had heard halla in the house of Ayub Ali, and then I rushed there and came to know that accused Ayub Ali stabbed his female child armed with a dagger, and also Ayub inflicted himself by the dagger. It is not a fact that I stated before the police that on being asked by the villager to the accused, then the accused told to the villager that he had killed his daughter due to quarrel with his wife, and that confession made by the accused in presence of me. It is not a fact that I'm giving false evidence on being asked by someone, some of the people told that the wife of the accused killed the daughter, and some of the people told that the accused killed his daughter. It is not a fact that I had heard that the accused killed his daughter. It is not a fact that I did not heard from any other person the wife of the accused killed her daughter. It is not a fact that at the time of occurrence I was not present in the periphery. Rather, I was in my house. It is not a fact that I'm giving false evidence in support of the accused. In his cross by the defense, I have not seen the occurrence. The police had not recorded my statement. I have not stated before the police that on being asked by the villager, the accused confessed that he killed his daughter. It is not a fact that I had not stated before the police that I rushed to the place of occurrence on being heard halla and heard from people that Ayub had stabbed his daughter and also inflicted himself by the dagger. I had heard that some of the villagers that the wife of the accused killed her daughter. Now, my lord, he was in charge of, my lord, the PW14 was the Bhavanipur outpost, my lord. On 24/7/2016, I was discharging as IC of the Bhavanipur outpost. On that date, about 8 AM, I got an information over phone from Purabharal Gaon that one Ayub Ali, son of Jul Hussain, killed his own 2.5-year-old baby armed with a dagger. The information was entered as Bhavanipur OP GD entry number 506 dated 24/7/2016. Thereafter, I visited the place of occurrence at Purabharal Gaon and also rushed to the house of the informant and the accused and saw the dead body of Suhana Akhtara Khatun, the daughter of the accused Ayub Ali, as well as the informant Asma Khatun, which was lying in the courtyard covered with a cloth of the house of the accused, and informant with injuries in her chest, oozing blood from nose, stained of blood near navel, blood stain in her left leg. The baby was wearing an orange color half pant. I came to know that accused, the father of the deceased, killed her armed with sharp weapon. I draw the sketch map of the place of occurrence. Exhibit 3 is the sketch map. Exhibit 3.1 is the sketch map. Thereafter, I conducted inquest over the dead body in presence of the witnesses and also recorded their statement, namely Ayub Nabi Gaungura, Kobat Ali, and Sahidul Islam. Exhibit 2 is the inquest report and Exhibit 2.4 is my signature. I also recorded the statement of namely Jiaur Rahman, Joinal Abidin, Nazrul Islam, Abdul Mutlab, and Siraz Ali. Thereafter, I sent the dead body for post-mortem examination to ascertain the cause of the death. I came to know that the accused himself inflicted himself by the dagger. As a result, he sustained injuries and his brothers already brought him to FAAMCH Barpeta for treatment. I came back to the outpost. On that very day, in the evening, I went to the FAAMCH Barpeta to know about the accused and then came to know that the accused had already been admitted and as such, he could not be interrogated. Since I found implicating material of the alleged offense, as such, I provide security to the accused at hospital. On that very night, about 9 PM, I received an ejar from the informant. The ejar was entered as Bhavanipur OP GD number 516, dated 24/7/2016, and forwarded the same to the Barpeta PS to register a case, and accordingly, a case was registered as Barpeta PS case number so-and-so under section 302 IPC, and I was entrusted to complete the investigation. In the Azahar, the informant had put a thumb impression. Exhibit 4 is the Azahar. Exhibit 4.1 is my signature. Exhibit 4.2 is a signature of Amrit Kalita, then OC Barpeta, who I know. I had also recorded the statement of the informant, which I knew. I also recorded the statement of the informant. On the next day, I got an information the accused has already been released from FAAMCH Barpeta and immediately went to FAAMCH Barpeta and apprehended him and brought him to outpost. During the interrogation, accused Ayub Ali confessed before me that he had killed his daughter in the presence of some witness, namely Nasirul Haq, Manirul Haq, Saruddin, Julas Badshah at Bhavanipur outpost. On getting sufficient material of the alleged offense, I arrested accused Ayub Ali and thereafter he was forwarded to the learned SDGM, Bajali, along with a prayer for recording the confessional statement of the accused under section 164 CRPC, but the accused declined to confess before the magistrate. Exhibit 5 is a prayer for recording confessional statement of the accused, and Exhibit 5 is my signature. On 25/10/2016, I collected the post-mortem examination of the deceased. After completion of the investigation, the case was charge sheeted against Ayub Ali under section 302 IPC. Exhibit 6 is a charge sheet, and 6.1 is my signature. I recorded the statement of witness Joinal Abidin, and he stated before me under section 161 CRPC that on today, I had heard the accused Ayub Ali killed his minor daughter, aged about 2.5-year-old. And in that regard, there was a halla in the entire area of our village. And then I went to the house of the accused and came to know that there was a quarrel between the accused and his wife. And the accused took away from the lap of his wife and took her away from the house. And thereafter, he killed his daughter armed with dagger by stabbing the minor. I recorded the statement of witness Kobat Ali, and he stated before me that under section 161 CRPC, that the accused Ayub Ali had suspected the informant and knowingly stabbed his daughter, namely Suhana Akhtara, as a result of she died. I recorded the statement of witness Sahidul Islam, and he stated before me that under 161 CRPC, that I had heard from the people that the accused Ayub Ali had stabbed his daughter by the dagger as a result of she died. I recorded the statement of the witnesses Nazrul Islam, and he stated before me under section 161 CRPC that on today at about 7:45 AM, accused Ayub Ali stabbed his daughter Suhana Akhtara by a dagger, and a hue and cry took place in relating to the occurrence. And then I, along with villagers, came to the house of the accused and came to know that the accused killed his daughter by causing injury and also inflicted himself as a result of he also sustained injury. And the accused killed her daughter due to family disturbance. Quarrel took place with his wife. PW 212 Muhammad Jiaur Rahman stated before me under section 161 CRPC that on today morning, in the morning, there was a quarrel took place between Ayub Ali and with his wife, and Ayub murdered his 2.5-year-old female child and also inflicted himself. PW 13 Abdul Muttalib stated before me that under section 161 CRPC on today, in the morning at about 7:45 AM, I had heard Allah in the house of Ayub Ali. And then I rushed there and came to know that the accused Ayub Ali stabbed his female child armed with the dagger, and also Ayub Ali inflicted himself by the dagger. In the cross-examination, I went to the place of occurrence in connection with the Bhavanipur OP GD number 506 dated 24/7/16. The GD entry was recorded at the telephonic information from an unknown person. The GD entry was first information of this case. I started investigation on strength of that GD entry. After completion of partial investigation, the basis of the GD entry at that night, at about 9 PM, I received the formal Izahar from the informant, and that Izahar was entered in Bhavanipur OP GD number 516 dated 24/7/2016 and forwarded the same to OC Borpeta. I had not brought the extract copy of the Bhavanipur OP GD number 506 dated so and so. In the sketch map, as sketch map, I indicate A as a place of occurrence, but there was not specifically mentioned. I did not record the statement of the father-in-law, brother-in-law, and nephew of the informant. It was not mentioned specifically the shape of the sharp weapon. Though I tried to recover the weapon, it could not be recovered. No blood stain of disease was shown to me, nor I seized any cloth. I had not noticed any blood stain in the place of occurrence, at the place of occurrence. Witness Asma Khatun PW2 did not state before me that she had been torturing by the accused for 4 days from the date of occurrence. Witness Nazrul Haq PW3 did not state before me that on the next day of the occurrence he went to the Bhavanipur Panchayat office. Witness Azaruddin PW6 did not state before me that on the next day of occurrence he went to the Bhavanipur Panchayat office along with his friend Padsha. Witness Mainul Ali PW7 did not state before me that the accused stated that he had committed wrong, and as such you would do what you like. Witness Ayub Ali PW8 did not state before me that he was in the house. Then Ziarul told him over phone about the occurrence. It is not a fact that PW5 Jainal Abidin did not state before me. On today, I had heard the accused Ayub Ali killed his minor daughter aged about 2.5 years old, and in that regard, there was a halla in the entire area of a village. And then I went to the house of the accused and came to know that there was a quarrel between the accused and his wife. And then accused took away from the lap of his wife and took her away from the house, and then thereafter he killed his daughter armed with dagger by stabbing on the minor. It It is not a fact that on that PW9 Kubat Ali did not state before me that accused Ayub Ali had suspected the informant and knowingly stabbed his daughter, namely Suhana Akhtar, as a result of she died. It is not a fact that PW10's Sahidul Islam did not state before me that I had heard from people that accused Ayub Ali had stabbed his daughter by dagger, and as a result she died. It is not a fact that PW11 Nazrul Islam did not state before me that on today at about 7:45 AM, accused Ayub Ali stabbed his daughter Suhana Akhtar by a dagger, and a hue and cry took place in relating to the occurrence. And then I, along with the villagers, came to the house of the accused and came to know that accused killed his daughter by causing injury and also inflicted himself, as a result of he also sustained injuries. And accused killed her daughter, due to the family disturbance quarrel took place with his wife. It is not a fact that the PW12 Ziaur Rahman did not state before me that on today in the morning there was a quarrel took place between Ayub Ali and his wife, and Ayub murdered his 2.5-year-old female child and also inflicted himself. It is not a fact that PW13 Abdul Muttalib did not state before me that on today in the morning about 7:45 AM, I had heard Halla in the house of Ayub Ali, and then I rushed there and came to know that the accused Ayub Ali stabbed his female child armed with a dagger, and also Ayub inflicted himself with a dagger. While the accused confessed about the occurrence to me in presence of other witnesses at the time he was in my custody, there was no any magistrate was present at the time of making confession to me.
Yes.
Now, my lord, this is the 313th statement, my lord. 313, my lord, he has basically denied all the allegations, my lord. And my lord,
It's a case of denial only.
denial, my lord, 26, my lord, serial
No
number 26.
explanation.
No, serial 26, my lord. Do you want to say anything in this case? I am innocent. I knew that my wife Asma Khatun had illicit relationship with one boy. And when I asked her about the occurrence, then she made quarrel with me, and thereafter she had killed her daughter, Suhana Akhtar, and also assaulted me with a chaku, as a result of which I sustained injuries. Later on, my Asma Khatun also got married with that boy. And when he was asked to produce evidence, he said he did not want to produce any evidence. So, my lord, his case was that, my lord, his wife had killed, my lord, the child. My lord. That is what he had, my lord, stated in his 313th statement. Now, my lord, what I find, my lord, first of all, my lord, of course, there was no recovery of the weapon, my lord. Secondly, my lord, the material witnesses, my lord. Because the PW2, she is the only eyewitness, my lord. Otherwise, there is all, my lord, hearsay evidences, my lord, saying that we heard about this incident. Though there was someone declared hostile, but then it was because of the fact that they were telling that there was conflicting stories about who killed the child. Whether the father, it was the
But
mother.
they say they heard only.
They heard. So everything, yeah. Yes, madam.
One wonders why they were declared hostile.
Yes, madam. This is there.
They did
But
not
then-
produce any evidence.
They don't
It's all hearsay.
All hearsay, madam. What, my lord, what my lord strikes, my lord, is that, my lord, the in-laws, the PW2 has herself admitted, my lord, all the in-laws were in the house, my lord, at that point of time. And none of them has been examined, my lord. They were not even, my lord, the investigating officer has said, my lord, he didn't even take the statement, take the statements also, my lord. So they are the material, they were perhaps the material witnesses, my lord, lend credence to the story of either side, my lord. And they were totally ignored, my lord. And therefore, my lord, it's not a case where, my lord, there is no other hypothesis possible, my lord, that it is.
What other hypothesis possible?
It's quite possible that the wife had killed the daughter, my lord. Quite possible, my lord. Because she had then later on married the boy, my lord, and gone with the boy whom she, my lord, was having a relationship with, my lord. Quite possible that she might have also killed, because apart from her statement, my lord, there is nothing on record, my lord, that, my lord, this person killed, my lord. And, my lord, these persons who were there, my lord, this in-laws, my lord, they were material witnesses, my lord, because she was saying that, my lord, they were all sitting in the, my lord, courtyard, my lord. PW2 lordship will see, if your lordship sees, my lord. He had made a very specific statement in a cross-examination, my lord, page 11. At the time of occurrence, my in-laws were in the house. At the time of occurrence, my father-in-law and brother-in-law Isab Ali were sitting in the courtyard. The neighbors are far away, that's another issue. But then she specifically said, my lord, that these people were sitting in the courtyard, my lord. They were very much present in the house, my lord. And it was a,
So according to PW2,
my lord,
the incident happened on the road,
on the road.
and that is where the body was found.
Yes.
That is established.
Yes, body was there. Yes. Because well, there is another story, my lord, that she took the girl with my lord to some other place, my lord, then came back, my lord. So there was some, my lord.
But the accused does not say so.
Accused doesn't say, my lord. Accused only said, my lord, she had killed her. That is what he's saying. And my lord, these people, since they were there, my lord, they ought to be examined, my lord. These are very well material witnesses, my lord. Because they are
They have to be examined on what point?
well, about the incident, because they could have been, my lord, because they were there at that point in the house, my lord. Whether there was a quarrel, whether he took the girl away, my lord, all these things could have been, my lord, they could have disclosed, my lord. Because they were very much in the courtyard. It's someone going out of the house, my lord. It's not possible, my lord, that they would know nothing, my lord.
So what happens if they are not examined, then what will be the consequence here?
My lord, since, my lord, there is no other, my lord, witness, my lord, only the informant, my lord, and the accused is also saying that, my lord, she is the person responsible, my lord. So therefore, my lord, these witnesses could have are material, my lord. They could have, my lord.
So what will happen now, since it has not been done? What is the law?
My lord, I think, my lord, the benefit of doubt should go to the, my lord, accused, my lord.
Where is the law?
Well, because, my lord, there's no other, because it has to be, my lord, it has to be proved, my lord, that this is a person beyond a reasonable doubt, my lord, that he is the person who killed, my lord. That is not there, my lord. So unless that is there, my lord, there is the other hypothesis that is possible that the wife killed the daughter, my lord.
But why would the wife kill?
Just because the husband could kill, the wife could also kill, the father. If the father can kill, the mother can also kill, my lord. It's not, my lord, that only the father can kill, the mothers cannot kill, my lord. Because she had a motive, my lord, she wanted to go with someone else, my lord. Perhaps that's the reason she didn't want to, my lord, have anything, my lord, no legacy, my lord.
Where is the, let us see the cross-examination of PW2 once again.
Yes, my lord, page 11, my lord. In her in chief, my lord, she said that after leaving the courtyard and while they reached on the road, they immediately accused, armed with a dagger, stabbed the child in achievement. And in her cross-examination, she was saying that the other father-in-law and brother-in-law were sitting in the courtyard at the time of occurrence.
Mr. Datta, the problem is this case was not made out during the cross-examination of the PW2.
That was not there. It should not ask this question, of course. That is there. Should not ask this
So
question.
suddenly the accused coming and just making a bold statement that she killed me. Where, how, no particulars, nothing. It does not at all
But then they will not, if the Milord, of course.
That does not raise a doubt.
But then if the other Milord witnesses are Milord, though hearsay, Milord, their statement was that they heard that some people are saying, Milord, that someone had killed. The other story was that the wife had killed.
That is correct, but
So-
first of all, they are hostile witnesses.
My lord.
But their version does not find corroboration from any other cogent evidence.
My lord.
But even assuming that they were not, even then, this is all hearsay. Someone has told.
My lord.
Who is that someone?
That's right.
Just
my lord.
by saying that, that's not evidence.
That's right, my lord. That's right. But then
These
since,
hostile
well,
witnesses,
since,
they did not depose on any material point.
yes,
What they heard, who said, who knows? That's all.
exactly.
hearsay.
Of course, they did not say anything in material. But my lord, since the Milord, that's why my lord, my case would be my lord, that
So
basically.
did the husband lodge any complaint, any ejahar or any family members lodged any complaint?
No, my lord, there is nothing on record to show that.
That is also not.
That is not.
If the husband's version is to be believed, then incident happened inside the house. Nobody from the family lodged a complaint
No,
or
no,
ejahar.
no one lodged. No one lodged a complaint, my lord. That is not there. But my lord, that's why my lord, perhaps the police ought to have investigated, my lord, taken the statements and my lord, these people were my lord, vital witnesses in this case, my lord, the father-in-law, the brother-in-law.
Now, do you have any authority which says,
My lord, material witnesses, my lord, who can, my lord, lay, yes, my lord, I've relied on 3 judgments, my
the
lord.
material witnesses, Mr. Datta, please
My lord,
appreciate one thing. If there is a missing link
my lord.
and there are with material witnesses who could have clarified and the IO fails to record their statement or prosecution fails to examine them, then this failure to establish the missing link in the chain would obviously punch a hole in the prosecution case based on circumstantial evidence. And to that extent, it can be said that it has a fatal bearing. But that principle will not be applicable here because the person who has seen the occurrence has testified. She has given the whole version. Correct. She has said, testified before the court that this is how it happened. So there is evidence to give a clear view of what has happened. Whether 2 other witnesses should have been examined or not, that will not then put a dent in the prosecution case.
My
Unless
submission,
you can show a judgment.
my
Because
submission.
all these are based on, you see, some principles.
My lord.
Yes, on circumstantial evidence, chain, each link in the chain has to be. In the eyewitness case, no question of proving each link in the chain. Because it is a direct evidence case. So the principles governing circumstantial evidence, those principles will not be applicable here.
Well, my submission would be, my lord, since there is some doubts have been raised with regard to.
Where is,
My lord, of course, my lord, nothing beyond the 336. That's the only way it's been
no
raised.
doubt. But
Because
if
my lord,
you- if you want-
the fact
you
that
can
the fact,
show us some judgment on the principle,
my lord,
then we can consider, but otherwise, just by giving his version appears to be totally untenable for many reasons. First of all, he does not give any particulars of how it has happened.
it doesn't.
If his version is to be accepted, then how the body was found, the injured victim was found in the road, that
No, my lord, my lord, there's some statements of the my lord, wife, my lord, the informant, my lord. She, my lord, said that she took the body, she ran after, my lord, for what was the hospital, my lord. And then, my lord, she fell down.
that
Then
is
she-
evidence.
Then she was brought, my lord.
That is evidence. 313 statement is not evidence.
Not evidence, not evidence,
That is,
not evidence.
her evidence is
Yes.
evidence. She's not been challenged or shaken in the cross-examination. It remained intact. There was no suggestion that she is the one who is the culprit.
Of course,
Nothing.
definitely not. That was definitely not. That suggestion of my lord, perhaps ought to been there, has not been there, my lord. That's a fact. That suggestion was not made.
PW2, that is her testimony. And the only evidence here is forensic PW2 and the IU. Rest are all hearsay.
That's all,
They
yes.
have not seen anything.
That's there, my lord. That
not
is something
seen
which cannot be, my
But
lord.
this PW2, PW1 and IO PW14, their story fits in. There is no inconsistency. Rest of them, whether they are hostile or not hostile,
That's a
they have not seen anything.
Yes,
They have heard.
they only heard. That is there.
Whether it goes here, this side or that side has no bearing. They are not witnessed. They did not depose on any fact.
True, man.
They have seen.
That is there.
What they have heard is, it, there is no value.
My lord.
But if the husband's version is to be accepted, then the prosecution case will turn turtle. Right? Only a bald statement without anything supporting, no HR, no complaint, no family member coming forward to depose, nothing, not even a whiff of material which supports his version, no evidence. That is not doubt. Doubt has to be a reasonable doubt. A accused person to save himself may come up with any story. But that story has to fit into the circumstances, established circumstances.
My lord, since my lord, he has also made a statement that she had gone away with that boy with whom she was having an affair. My lord. That, my lord, kind of, my lord, that has also not been, my lord, of course, that is again in 3 and 10 statement. That was also not put in, my lord, whether she ran, my lord, after this, in lord, after the, my lord, she went away, my lord, after the evidences were reduced and all, but that is also not very clear. But, my lord, that's where he, my lord, that's the only thing he had said. That's the only place where some doubt is created, my lord, and of course, my lord, apart from that, my lord, the only thing that's, my lord, that was my submission is that the only thing is that since the other two, they could have, my lord, let credence to the story, the father and the brother-in-law, because and they were, since they were there, my lord.
Where is the injury report of the accused?
Injury report, the accused is not there, my lord, in the record, my lord. It's only the daughter's injury report is there, if I'm not wrong, my lord.
That is there in the PM postmortem report.
It's similar child only, my lord. This child is, my lord, at page 66, my lord. I don't see in the injury report of the, my lord, that was not exhibited, my lord. No, that is not there. And so far, the investigating officer is saying, my lord, that he did not say, she did not say anything that they were having some quarrel for the last few days, my lord. That the investigating officer in his statement, though she has tried to say, my lord, that they were having some quarrel. But, my lord, the investigating officer, of course, did not say, my lord, that said that he should not make any such statement for him. Page 35, my lord. Witness Asma Khatun, PW2, did not state before me that she had been torturing by the accused from 4 days from the date of occurrence. And, my lord, if your lordship looks at her statement, my lord, she was saying, my lord, that the child was there, my lord.
Has the accused ever said that he is innocent?
Lord, in his 313, he's been saying he's innocent, my lord. That
Where
is,
did he say he is innocent?
that is, this is consistent stand, my lord. I am innocent, my lord, page 20, my lord. First thing he says, do you want to say?
1 minute, 1 minute. Please. They've heard. They are not witnesses. They don't qualify. This is not evidence. Even if they say father, that is also more evidence. Yes, which page?
My lord, page, my lord, 44, my lord, that state, my lord, question, do you want to say anything on this, in this case? He said, first thing he says, I'm innocent.
All right, so anything else you want to develop, any other legal?
Well,
point?
Lordship is similar again, once again, page
Please
10.
don't repeat what you have.
Yeah, well,
already
page 10, Lordship will see just once again, the PW2's witness, my lord. Just want to point out one thing, my lord. About 4 days back, from 24/7/2016, accused as well as my husband has been quarreling with me on demand of money to be brought from my parental house. She did not say anything before the police about that. While I was sitting inside my house along with the child in my lap, then the accused forcefully taken away my child Suhana Akhtara from my lap and went to out of my house telling me that he will purchase biscuit for the child. But I had suspect upon the accused and as such followed him. Well, why would she suspect beforehand that she was doing?
That question, how can we answer?
That's true, my lord.
asked her.
So that's the reason, my lord, I'm saying, my lord, that she had something, my lord, something more than, my lord, what Mirza, my lord. She had she was suspecting that something of that kind would happen, man. That is what she is trying to say by her, my lord, in her evidence, my lord.
Mr. Datta,
Therefore,
we cannot go.
Then I understand, my lord. So, my lord, since that is why I'm saying, my lord, since there is, my lord, the story, my lord, as if one looks at the evidence, my lord, the accused, my lord, also the informant, my lord, she has stated that she killed him, my lord. He killed his daughter. But at the same time, my lord, there are certain statements, my lord, which raises some doubt because, and my lord, since he is also saying, my lord, his wife had killed him, my lord. Therefore, I'm saying, my lord, these witnesses, my lord,
Where is the evidence which says his wife is killed?
of course, my lord, there is no evidence. There is no evidence, my lord. There is no evidence.
There is evidence that he has killed. There is no evidence that the wife has killed.
That is there, my lord. It is there. There is no evidence that he has killed, my lord. But
Then how can we?
Since he has
Reasonable doubt has to be created on the
My lord.
basis of evidence on record, not by any other means. These are people who have just casually said, oh, they have heard this, they have heard that. How does it matter?
I'm not relying upon all those, my lord. I'm not relying on all
What
those
else
because
is there?
they have heard, my lord, and they will, for whatever reasons, my lord, rightly or wrongly, they've been declared hostile. That's a different part. So, what I'm on, my lord, is basically the 313 statement, my lord, where he has made some, my lord, imputation, my lord. And, my lord, the way she has, my lord, in her evidence, she has narrated, my lord, the story, my lord. It appears, my lord, that quite possible, my lord, that she was saying that I suspected that my husband is going to do something with the child. That's very well. That looks very unreasonable.
That's correct. So if it is really a case where the wife has killed the child just because she wanted to marry someone else. Oh, there was a world of thing he could have and should have done. He should have lodged an ejahat.
That is there.
Family members could have.
Yes.
He does nothing. And in 313, he just makes a bold statement without giving any particulars. And according to his statement, it seems the wife killed the child inside the house. That's what he says, which is totally incorrect because the evidence of other witnesses shows that it all happened outside the house.
No, but the other witnesses do not say anything, my lord.
Oh, what about the IO?
IO also, my lord. IO, my lord, so
he prepared a sketch.
No, my lord. He came there, my lord, whatever he was told, my lord, because he was also not an eyewitness to the incident. So he will only say, do whatever, my lord, wherever he finds the body, my lord. He finds the body at a particular place, my lord. He draws a sketch.
Naturally.
So he cannot go beyond that. So
these are always prepared on somebody else.
Yes, sir, definitely, but he cannot go beyond that. So therefore,
the wife has sinned.
My lord.
She has adduced. Her evidence is not challenged.
My lord.
It is a question of death of her child. Why would she falsely implicate the husband? And if it was the case, then why would the husband keep quiet?
course, that, of course.
Logic has to be,
That, of course, my lord, perhaps, my lord, I don't know, my lord, that, of
Logic
course,
cannot take a
I cannot,
back
my lord, assumptions and presumptions, my lord, that he got to be advised properly or this and that, my lord, or he was not advised, that I also cannot make, my lord. That, of course, is there, my lord. I cannot, my lord, say that he was not advised properly, that I cannot say. But then, my lord, therefore, my lord, my entire submission is based on the fact that there are two other witnesses, my lord, who could have, my lord, perhaps lent, my lord, the credence to the entire story, my lord, and made it a story, my lord, which could have been proved beyond reasonable doubt. Here, since the imputation was made with regard to the wife's, my lord, behavior, my lord. Therefore, my lord, these witnesses, my lord, become vital, my lord. This father-in-law, brother-in-law, who were supposed to be, my lord, sitting in the courtyard as she has admitted, my lord. This is her statement, my lord, that they were sitting in the courtyard when the girl was taken out of the house. So therefore, my lord, again, my lord, she said there's a road in front.
no,
Then-
that statement is not correct. She said at the time of occurrence, they were sitting in the courtyard, not when the girl was taken out.
No, my lord, when, my lord, lordship will see, my lord, in our evidence in chief, after leaving the courtyard and while they reached the road, immediately the accused armed. So after leaving the courtyard, so they left the courtyard and these people were sitting in the courtyard. In the cross, she has stated that these people are sitting in the courtyard. And in our chief, my lord, she was saying, I followed them. She said that the child was taken with the plea that he will buy a biscuit for the child. She did not say that she was angry on the child also. He said that I'll buy a biscuit for the child. And then she said, I suspected him. Then after leaving the courtyard and while he reached on the road, then immediately accused armed with a dagger. So, my lord, if our version is to be believed, my lord, just leaving the courtyard and reaching the road, she stabbed, my lord. So therefore, my lord, these two persons could have been the eyewitness, my lord. They were not just, my lord, sitting in the courtyard. Then, my lord, if the incident happened just in front of the road, just, my lord, reaching the courtyard, my lord, reaching out of the courtyard, my lord, then these two people are eyewitnesses, my lord. They have not been examined, my lord. And, my lord, then she in a cross-examination, she said the place of occurrence is the backside of our house, my lord. Once she says in front of the, my lord, after leaving the courtyard, well, they reached the road, immediately accused armed with the dagger, stabbed the child 3 times in the chest. And then she says the place of occurrence is the backside of our house. So therefore, there is some contradiction here also in her where the incident took place. And, my lord, these two witnesses, my lord, if her story is to be believed, my lord, then, my lord, not only they were, my lord, sitting in the courtyard, they are supposed to be eyewitnesses, my lord, of the incident. They were not even examined, my lord. Even the investigation also they were not examined.
No, Mr. Datta, we have already said, you see, who is to be examined, who is to be not, this is a matter for the prosecution to decide. But it will have a fatal bearing if there is a missing link in the chain which could have been clarified by witnesses who were present or who have seen it, but the prosecution did not examine them. Then obviously, since the chain is not complete, in a case of circumstantial evidence, this will go against the prosecution. And even under 114G, the Evidence Act, it will go against them. But you are employing this argument in the case of eyewitness. Unless you show that she is not eyewitness, nothing else will matter.
Of course, I cannot say that she is not happening.
Nothing else will matter. Nothing. Somebody comes and says, I have seen this happen in front of my eyes. If her evidence or his evidence is found to be believable, where the links are missing, how does it matter?
No, well,
Chayo has not
true,
done
but she is making a statement. That's true, madam. She is making a statement, but at the
Can you
same time,
show us there is any contradiction in her evidence?
that's the only contradiction that I pointed out, madam, that she had said that, my lord, that the fact that she was suspecting some kind of incident, some kind of, my lord, act on part of the, my lord, accused.
So
And then, my
what is
lord,
the contradiction here?
contradiction is, my lord, normally, my lord, if the father says that I'm taking the child to buy a biscuit for my daughter, how can the mother suspect that?
Oh, that question ought to have been asked to her.
Because that,
How can the judges sitting here?
of course, that is there. Like
You didn't ask
that
because
was
you knew that there was reasons for suspicion.
that was not asked.
That is how the
That is
law will operate. You did not ask it because you knew the answer that there was some ground for it. That's why you didn't ask the question. That's how we will go.
Of course, that is of
Whether
course.
in a particular case, somebody was rightly advised wrongly, we can't go into all these
Yes, of
things.
course. That's the reason I didn't argue with that.
If
I
a
was-
question is not asked,
My lord.
that means the answer is no. And that answer is not favorable to the party examining or calling or who has the witness in the docs. That is the presumption in law.
Those things are all there, my lord. But under normal circumstances, my lord, what would happen, my lord? A murder take place at a house, my lord. Who are the immediate persons, my lord, who are to be, my lord, examined, my lord?
You are again going back to the same. These are hypothetical scenarios. We are not going to go into that. We will only see whether the evidence is good enough to sustain his conviction. What could have been done, what should have been done, unless you tell us that this is the law and give us an authority. We are not going into all these things. Only thing we need to see is whether there is evidence to say that the charge has been proved beyond reasonable doubt. If it is a case of circumstantial evidence, we'll have to see whether the links in the chain are established. If it is a case of direct evidence, we'll examine whether the eyewitnesses are consistent, their testimony is free from contradiction. Even if it is one witness, it's good enough.
That's true.
So you have to show us
That is
all
true.
that you are arguing today. These are not the case projected in the trial court. No cross-examination, no suggestion. There's nothing to say that you are you are the one who has killed the child. It happened inside the house. You had a relationship with someone. That's why you did it. Nothing.
Nothing was put forward.
Yeah.
Of course, that is there.
Unless these are done today, how do we know how the witness would have reacted? Maybe she would have admitted, maybe she would have denied. So we can't reconstruct a trial scenario today and take another view.
That we cannot.
If something could have also happened, some UFO could have hit the child. Oh, that is not a doubt. That's an absurd theory. Doubt has to be created on the basis of materials on record, evidence on record. The evidence should be capable of suggesting that another possible scenario is also cannot also be ruled out.
But that's
Not
where
because
the-
suddenly entirely contrary to the projected case, the accused says something, he makes a bold statement, doesn't give any. If his daughter was killed by his wife, why did he remain silent? Why did he not lodge a police complaint? Why did his family members remain silent? There is nothing.
There's nothing.
Yeah.
No
How can we accept these absurd theories? Ms. Bhuya, you argue too.
My lord.
And if you have really something which is legally important, otherwise you've done your job. Let's not push it beyond the limit, but if you think there is some legal issue which is of serious nature, then you can come at 2 and tell us.
Let her make a submission. If reply, my lord, if I can. My lord.
If she makes a submission, we'll close it. We'll not
Well-
grant you time for further
No,
research.
my lord, not, I mean, today, whatever, I'll go today. I'll not drag it further, my lord.
We'll come back at 2.
My lord. Witness PW2, who happens to be the wife of the accused person and the mother of the victim, my lord. Lordship, her evidence is consistent throughout, your lordship, 161 statement as well as in a substantive evidence, your lordship. May I take your lordship to the evidence of PW2, my lord? At page 10 of the paper book. I am the informant of this case. Accused Ayub Ali, Ayub Hussain, who is in the dock, is my husband. This is Suhana Akhtara, who was 2.5 years old at the time of occurrence, is my daughter. Suhana Akhtara was our only child who was born out of a wedlock. At the time of occurrence, I was with my husband in my matrimonial house at Pura Bharal, PS Borpeta, and after the occurrence, I have been staying at Moiramara Gao so and so. About 4 years back from 24th, 2016, accused as well as my husband has been quarreling with me on demand of money to be brought from my paternal house. On the day of occurrence, that is 24/7/16 in the morning hour, about 7 a.m. while I was sitting inside my house along with my child in my lap. Then accused forcefully, your lordship will kindly note, accused forcefully taken away my child, Suhana Akhtara, from my lap and went out from my house by telling me that he will purchase biscuit for the child. But I hadn't suspect upon the accused, and as such I followed him. After leaving the courtyard and while he reached on the road, then immediately accused armed with a dagger stabbed the child in 3 times in her chest and stomach in front of me and fell the child beside the road. I raised Halla and picked up the injured, my daughter, child, and ran towards the hospital. But suddenly I fell down along with the injured child and found the child is dead. There were oozing blood from the injured places of the child. I fell senseless on the road. Someone brought me to the house along with a dead child. There was a huge gathering in my house, and after some time, police came to my house and brought the dead body of the child to hospital. On that very day, I lost the Azahar with the police. On that very day, the dead body of Suhana Akhtar was handed over to us. Just after the occurrence, the accused fled away. In the Azahar, I put thumb impression. The police recorded my statement. On that very night, I left the house of the accused and started to stay in my paternal house. In cross-examination, my lord, I had been staying in my matrimonial house along with my husband, child, mother-in-law, father-in-law, brother-in-laws, and nephew. At the time of occurrence, my in-laws were in the house. At the time of occurrence, my father-in-law and brother-in-law, Ishaq Ali, were sitting in the courtyard. The neighbors are residing far away from my matrimonial house. There is also a Anganwadi center and one mosque. The Anganwadi center is running in the rented house of Salam. On the day of occurrence, the day was Sunday. The place of occurrence is just near my house. The place of occurrence is at the backside of the house. There is Village Road in front of the Anganwadi center. The Azhar was lost at night about 9 p.m. on the very day of the occurrence. It is not a fact that I did not state before the police the accused had been torturing me from 4 days back from the date of occurrence. It is not a fact that at the time of occurrence, I was not sitting in my house along with the child in my lap. It is not a fact that I did not follow the accused while he took away the child from me. It is not a fact that the accused did not step armed with dagger and kill my child. So, your lordship, since the accused was armed with dagger, he had the intention to kill the victim, my lord. It's not the dagger is found everywhere in the household, your lordship. And in the 161, I have checked. She is consistent, my lord, and she can be taken as a starling witness, as has been held by the Honorable Supreme Court. When a witness is consistent in the 161 statement as well as substantive evidence, her statement may be relied on, my lord. I want to rely on lordship one judgment as reported in, my lord. 2020, I don't have a copy right now with me. 2023 SSC 443. Santosh Prasad alias Santosh Kumar versus State of Bihar. Paragraph 5.4.2, my lord. May I read the paragraph, your lordship?
Yes.
Well, Paragraph 5.4.2. In the case of Rai Sandeep versus Deepu Supra, this court had an occasion to consider who can be said to be a starling witness. In paragraph 22, it is observed that, and held as under, in our considered opinion, the starling witness should be of a very high quality and caliber, whose version should therefore be unassailable. The court, considering the version of such witness, should be in a position to accept it for its face value without any hesitation. The taste of quality of such a witness, the status of the witness would be immaterial, and what would be relevant is the truthfulness of the statement made by such a witness. What would be more relevant would be the consistency of the statement right from the starting point till the end, namely at the time when the witness makes the initial statement and ultimately before the court. It should be natural and consistent with the case of the prosecution qua the accused. There should not be any prevarication in the version of such witness. The witness should be in a position to withstand the cross-examination of any length and howsoever strenuous it may be, and under no circumstances should give room for any doubt as to the factum of the occurrence, the persons involved as well as the sequence of it. Such a version should have correlation with each and every one of other supporting material, such as the recoveries made, the weapons used, the manner of offense committed, the scientific evidence and expert opinion. The said version should consistently match with the version of every other witness. It can even be stated that it should be taken in the test applied in the case of circumstantial evidence where there should not be any missing link in the chain of circumstances to hold the accused guilty of the offense alleged against him. Only if the version of such witness qualifies the above test as well as all other such similarities to be applied, can it be held that such a witness can be called as a sterling witness whose person can be accepted by the court without any corroboration and based on which the guilty can be punished. To be more precise, the version of the said witness on the court spectrum of the crime should remain intact, while all other attendant materials, namely oral, documentary, and material objects, should match the said version in material particulars in order to enable the court trying the offense to rely on the core version of to see the other supporting materials for holding the offender guilty of the charge alleged. So in our case, Your Lordship, the witness was consistent all along. So there is nothing to disbelieve. She should not be, could not be demolished in a cross-examination, my lord. So it is sufficient to hold that the accused person is the perpetrator of crime, Your Lordship. There is nothing to doubt the credibility of this witness, my lord. In the event of the matter, Your Lordship, learned court was rightly held the accused person guilty and convicted him, my lord. That is my respectful submission.
I just shall place one judgment, madam, on 313, madam. That should not be taken very lightly. And my lord, it should be given due consideration, madam. And in view of my lord, what he has stated, my lord, my submission will be the same, my lord, what he has stated, my lord. Some lord credence ought to have been given, my lord. And the learned court had dealt with 313 statement, paragraph 29. My lord, paragraph 19, my lord, I've marked it, my lord. Sorry, I did not reserve a copy. There, my lord, the 313 statement, my lord, has to be, my lord, objectively considered, my lord. And
So court has not considered it all.
court has been simply said, my lord, that he has tried to shift the allegation and, my lord, that he could not substantiate his innocence, my lord. He is, my lord, because he did not substantiate.
Where is the finding?
Page 29, my lord. Sorry, no, page 58, paragraph 29, my lord. Page 58, paragraph 29. The accused in his examination under section 3 and 13 replied and took plea that rather the informant as well as the mother of the deceased, so and so, had killed the daughter as well as the deceased. But in that regard, the defense side does not adduce any evidence. Though the accused shifted the burden to him to prove the case beyond reasonable doubt, the informant, PW killed her daughter, but he completely failed to substantiate his plea. But he did not substantiate his plea, my lord. It's only a preponderance of probability that he has to raise, my lord. That's what has been held by this honorable apex court, my lord. As such, mere shifting of the allegation to the informant is not enough to show his innocence. I find no material in the record that the informant killed the deceased brother is a plea to escape from the guilt, my lord. That's the only explanation he has given, my lord. My humble submission is he is not required, my lord, to really, my lord, establish his innocence. He is only, my lord, to.
No, you are saying the court did not properly deal with the
position.
and what more could have the court said on the basis of
My lord, since he had made that statement, my lord, my humble submission is again, my lord, that
court should have accepted it to be true.
no, my lord, in view of the fact that, my lord, there are other, my lord, of course, though this was hearsay, my lord, everyone says that we heard someone so that she was having an affair or she had killed that child, my lord. And, my lord, the material witnesses is not examined, my lord. Since she has an axe to grind, my lord. Since she has an axe to grind.
We have asked you in the first step also.
My lord.
You see, you have to convince us on the basis of some sound principle.
My lord.
Is it the law that just if some material witness is not examined, the accused should be acquitted? That's the
No,
question.
not exactly, my lord. It all depends on the facts and circumstances of each case, my lord. Definitely.
Therefore, in the facts of this case,
My lord.
how does it make a difference?
Well,
Why other persons have not been examined? How does it make a
Well,
difference?
since, my lord, some doubts were raised with regard to her behavior, my lord, corroboration would have, my lord, definitely, my lord, had the case of the prosecution better, my lord. And the prosecution had those witnesses, my lord. Those were not brought in record. The prosecution, my lord, were not in such place that it was the prosecution had no other witnesses available. they had the witnesses available, my lord, who perhaps would have given credence to the story.
But is there any decision? The Supreme Court on this point?
My lord, one decision, my lord, where of course on a different level of the specs were definitely different, my lord. When Joginder Singh, my lord, paragraph 20, my lord, Joginder Singh, that is, my lord, I think I've given the judgment, my lord, morning I've given the citation, 1311 2014 11 SCC, my lord.
What is the point?
That is the point, my lord, here, my lord, non-examination of material witness is significant. It is because PW 311 is a really an interested witness, though the High Court has not agreed to the same. It appears from the materials on record that he had an axe to grind against the appellant. So my humble submission is that allegation was made against his wife by the accused, my lord, in his 313 defense. My lord, there appears to be some reason why the wife, my lord, had a reason to take revenge, my lord. And the fact that he had married the boy also, that is what is saying, my lord. So therefore, my lord, she had some motive to, my lord, implicate him, my lord. That is my basic submission. My lord. So therefore, my lord, the material witnesses, the brother-in-law, the father-in-law were material for this case, my lord, and they having not been examined. And she cannot be said to be a starling witness, my lord, in this particular case under the facts and circumstances of this case. Therefore, considering, my lord, this aspect, my lord, she will consider these two aspects. That much.
Let the judgments 2020, 2023. But Mr. M. Dr. Amicus, you are appearing as Amicus.
Amicus,
Amicus, appearing for the appellate. So had Ms. B. Real and Equity also resisted by Mr. J. Das, appearing for the state's arguments concluded. Judgment resolved.
Develop language. I had another matter 28, and I'm not prepared today, but another matter 28, I'm not prepared today, with some other.
When do you want to do it?
Lord, 29, no? 29. Can we, my lord, Friday, my lord, Friday. No, 11.
Yes. Which is the item?
Item number 13 is there, Lordship.
Item
Item number 13.
13.
13. Lordship.
You are ready?
Again, Miss Jahan has looked after. She's in Landa Court, man.
You do it tomorrow then.
I'll inform her. Thanks.